Welcome back to The John Brown Show. I'm your host, and if you are watching this, you are witnessing the collapse of a decade-long architecture of silence. We are not talking about a leak today. We are not talking about a whistleblower whispering in a parking garage. We are talking about the judicial dam breaking wide open. What happened today in Judge Mary Ann Keller's courtroom is not just a legal ruling. It is a historical demarcation line. There is the world before this morning, and there is the world after. For years, Donald Trump has operated on a singular, highly effective legal theory. Delay is victory. If you can clog the courts, if you can muddy the waters, if you can claim privilege over the colour of your tie and the weather on a Tuesday, you can run out the clock. That strategy just hit a brick wall named Mary Ann Keller. Let's be crystal clear about the magnitude of what just occurred. Usually, when a federal judge handles a discovery dispute of this magnitude, involving a former president of the United States, national security implications, and the sensitive internal deliberations of the executive branch, you get a written order. You get a sterile PDF uploaded to the PACER system at 5 p.m. on a Friday. It gives the defense team the weekend to spin it, to file emergency stays, to run to the appellate circuits and beg for a pause. Judge Keller didn't give them a PDF. She gave them a performance. She gave them a lecture on the Constitution that was delivered orally in open court, with the stenographer typing furiously and the cameras recording every bead of sweat on the defense team's brow. By reading her decision into the record, publicly and verbally, she removed the lag time. She removed the ability for Trump's team to frame the narrative before the truth got out. She effectively said, the public has a right to know, and they have a right to know right now. We have to analyze the psychology of this move before we even touch the documents. This was a power move. This was the judicial branch asserting its co-equal status in a way we haven't seen since the Nixon tapes case. When she looked down from the bench and dismantled Trump's arguments for confidentiality one by one, she wasn't just ruling on emotion. She was dismantling the entire Trumpian methodology of legal warfare. She stated that the public interest, the voters' need to know who they are voting for, supersedes the personal embarrassment or legal jeopardy of a candidate. That is a standard that will echo through American jurisprudence for the next century. Now let's get into the meat of it. The files. The huge collection of proof that the video referenced. We need to pass through exactly what this dump entails, because the devil isn't just in the details. The devil is in the metadata. First, we are looking at the records of confidential discussions. This is the nightmare scenario for any high-level operator who plays fast and loose with the rules. We are talking about the destruction of the illusion of the perfect call. These transcripts, according to the initial analysis coming out of the release, strip away the veneer of presidential duty and reveal the raw mechanics of a mob boss. We are reportedly seeing conversations where the quiet part isn't just said out loud, it's shouted. We have known about the pressure campaigns. We knew about the arm twisting. But reading the transcripts of Trump speaking to his inner circle, to the Giulianis, the Eastmans, the Jeffrey Clarks of the world, changes the texture of our understanding. It shifts the narrative from incompetence to malice. The difference between a president who is bad at his job and a president who is actively criminal often lies in intent. These files, according to Judge Keller's assessment, provide that intent. They show a man who was told repeatedly, "Mr. President, that is illegal," and who responded, in essence, "Do it anyway." That is the crime-fraud exception in action. For those of you who aren't legal scholars, let me break this down because it is the hinge upon which this entire door swings. Attorney-client privilege is sacred in Western law. You can tell your lawyer you buried a body, and they cannot tell the police. However, there is one major exception. If you use your lawyer to help you bury the body, the privilege evaporates. Judge Keller looked at these files and said, "This isn't legal advice. This is a conspiracy to commit a crime." That is why she released them. She is telling the world that the Department of Justice isn't chasing a political opponent. They are chasing a criminal enterprise that happened to operate out of the Oval Office. Then there are the banking details. Follow the money. It is the oldest cliché in investigative journalism because it is the only one that never fails. The ideology is flexible. The ledger is not. The release of these banking records and fund movement tracks is arguably more damaging to Trump's core brand than the political scandals. Trump sells himself as the billionaire genius, the self-made tycoon. But these documents reportedly show a desperate shell game. We are looking at potential evidence of funds being moved in ways that violate campaign finance laws, using donor money, the money of working-class Americans who bought the hats and the flags, to cover personal legal liabilities, and perhaps even facilitate hush money payments on a scale we hadn't realised. If these documents confirm that campaign funds were laundered into personal accounts or used to silence witnesses, we are moving past campaign finance violations and into the territory of wire fraud and racketeering. It paints a picture not of a wealthy man funding a movement, but of a movement funding a wealthy man's debts. That is a betrayal of the base that, if properly communicated, cuts deeper than any policy failure. Let's talk about the unlawful commands to staff. This ties directly into the timeline of January 6th, but it goes broader. We are seeing reports of directives issued to low-level staffers to destroy documents, to wipe servers, to bypass security protocols. This is the Nixonian cover-up, but in the digital age. When you have a president allegedly ordering a subordinate to violate the Presidential Records Act or to obstruct a federal proceeding, you are looking at specific chargeable felonies for every single instance. This is why the timeline matters. The judge released these now, not after the election, not next year, now. By flooding the zone with this evidence, she has effectively inoculated the public against the witch hunt narrative. It is hard to claim you are being persecuted for your politics when there is a spreadsheet in the public domain showing you authorized a wire transfer to a witness 2 days before their testimony. Facts have a weight that rhetoric cannot move, and Judge Keller just dropped a 10-ton weight on the scales of the 2024 election. The reaction from Mar-a-Lago has been predictable, but we need to analyse it as more than just a temper tantrum. When Trump goes to Truth Social and attacks Judge Keller, calling her a hack or a political operative, he is trying to do what he has always done, delegitimize the referee. But notice the shift in tone. There is a frantic energy to it this time. There is a specific venom reserved for when he knows he has lost control of the asset. The asset, in this case, is the truth. He knows that these documents are going to be used by Jack Smith in the federal election interference case. He knows Fani Willis in Georgia is going to comb through these looking for corroboration of the RICO charges. He knows Alvin Bragg in New York is looking at the financial data. Judge Keller didn't just hurt him in her courtroom, she supplied ammunition to every other prosecutor in the country. She globalized the evidence. That is why he is enraged. He is fighting a multi-front war, and his supply lines, his ability to keep secrets, have just been cut. We must also contextualize the role of the enablers in these documents. The video mentions the confidential discussions with advisors. These people, the Mark Meadows, the Rudys, the Sidney Powells, are now exposed. Their private doubts are now public record. Imagine the scene. Publicly, they are on television saying the election was stolen, saying the machines were rigged. Privately, these transcripts likely show them saying, "Boss, we have nothing. We are going to jail if we do this." That duality, that hypocrisy, is the smoking gun. It proves that the big lie was indeed a lie, known to be false by its architects at the moment they were constructing it. Let's go deeper into the January 6th connection mentioned in the video, the 187 minutes of silence, the refusal to call off the mob. We have heard testimony about this, but seeing the contemporaneous communications is different. If there are texts or notes from that afternoon where Trump is being told they are breaking the windows and he responds with approval or indifference, that is the definitive proof of dereliction of duty. It moves the argument from he was paralysed by indecision to he was using the violence as a strategic tool. That is seditious conspiracy. That is leveraging a riot to impede the certification of a constitutional officer. And let's look at the blocking justice aspect. Obstruction. This is often the crime that sticks when the underlying crime is too complex to prove. If the files show a coordinated effort to hide evidence from the grand jury, the moving of the boxes at Mar-a-Lago, the deletion of surveillance footage, then the case is simple. It doesn't matter if the documents were classified or not. It matters that the government asked for them, and you lied about having them. These files reportedly confirm the conspiracy to lie. That involves multiple people. That means conspiracy charges. That means people flipping. The judge's refusal to allow a stay or a pause is significant. Usually, in the American legal system, if you shout irreparable harm, a judge will freeze everything. Judge Keller said no. She determined that the harm to the public by not knowing was greater than the harm to Trump by the release. This utilises a legal balancing test that leans heavily on the First Amendment and the importance of an informed electorate. She is saying that you cannot run for the highest office in the land and hide your criminal liability behind the veil of that office. It is a radical transparency that challenges the imperial presidency. This decision sets a benchmark. It tells future presidents and the current one that the digital trail you leave, the financial corners you cut, and the illegal orders you give will not stay buried in the National Archives for 50 years. They can be unsealed in real time if the cause is just. It destroys the expectation of impunity. Think about the ripple effect on the Republican primary and the general election. Trump's strategy relies on being the victim. But victims don't usually leave paper trails of wire transfers and transcripts of them ordering subordinates to break the law. This evidence gives his political rivals, however few are left standing, a cudgel. It gives the independent voter, the suburban mom in Philadelphia, the working-class dad in Michigan, a look under the hood. They might tolerate the tweets. Will they tolerate the theft? Will they tolerate the calculated disrespect for the rule of law when it is laid out in black and white? The video mentions that nothing like this has occurred in our country's past. That is an understatement. We are in uncharted waters. We have a former president facing 91 felony counts across 4 jurisdictions. And now the evidentiary basis for those counts is flooding the public square. This is a stress test for the American experiment. Can the legal system hold a man accountable who has tens of millions of followers who believe he is above the law? Judge Keller seems to think so. She is betting her career, and perhaps her safety, on the idea that the truth still matters. Let's circle back to the wrongful orders. This is a military term often, an unlawful order. If you are a soldier and your commander tells you to shoot a civilian, you are duty-bound to refuse. We are seeing that dynamic play out in the White House. The files reportedly show staff members, lawyers, aides struggling with this exact moral dilemma. Some followed orders, some quit, some wrote memos to the file to cover their own backsides. Those memos to the file are likely what we are reading today. They are the insurance policies of the bureaucracy, and they are cashing out. The strategic thinking driving Trump's backlash, as the video analyzes, is purely about delegitimization. If he can convince 40% of the country that Judge Keller is corrupt, then the evidence doesn't matter. It becomes fruit of the poisonous tree in the court of public opinion. He is trying to nullify the jury pool. He is trying to make it impossible to find 12 citizens who haven't been poisoned by the narrative that this is all a Biden DOJ hit job. But Judge Keller's strategy counters this. By releasing the raw data, she bypasses the spin. It's harder to spin a bank statement than it is to spin a deposition. Numbers don't have political bias. We also need to talk about the sheer volume, the vast trove. When you release 1 million pages of documents, you create a crowdsourced investigation. It's not just the NYT and WAPO looking at this, it's the internet. It's forensic accountants on Twitter. It's legal eagles on YouTube. They will find connections the FBI might have missed. They will link a flight log in this release to a meeting in a separate release. The hive mind is now working on the Trump prosecution. That is a terrifying prospect for a man who thrives on compartmentalization. The video mentions the enduring mark of the spoken delivery. This is crucial for history. In 50 years, when documentaries are made about this era, they will play the audio of Judge Keller. They won't show a screenshot of a legal brief. They will play the sound of a woman's voice calmly, methodically tearing down the walls of a corrupt castle. It humanizes the law. It reminds us that the law isn't a machine. It's a series of decisions made by people who have sworn an oath. Let's look at the specific danger this poses to his other active lawsuits. In the New York civil fraud case, this evidence of financial fluidity and hiding assets reinforces Judge Engoron's findings. In the E. Jean Carroll defamation saga, it establishes a pattern of lying and attacking the judicial process. In the Georgia RICO case, it proves the acts in furtherance of the conspiracy. Evidence is fungible. It flows between cases. Judge Keller just opened the reservoir, and that water is flowing into every courtroom where Donald Trump is a defendant. The John Brown Show exists to cut through the noise, and the noise right now is deafening. You have the right-wing media ecosystem screaming about tyranny. You have the left celebrating, but we need to look at this coldly. This is a stress test. If Trump survives this, if he can weather the release of proof that he committed crimes and still win the presidency, then the system has failed. Judge Keller has done her part. She has put the truth on the table. Now it is up to the jury and ultimately up to the voter. There is a tragic irony here. Trump, the man who obsessed over leaks, who wanted to jail journalists, is now being undone by the ultimate leak, the official record. He is being undone by the fact that in a democracy, the government belongs to the people, and the people's records belong to the public. He tried to privatize the presidency, to turn the White House into a subsidiary of the Trump Organization. This ruling is the foreclosure notice on that effort. As we wrap up this deep dive, consider the bad intent mentioned. Mens rea. Guilty mind. It is the hardest thing to prove in court. You usually have to infer it. But if these files contain what they are rumoured to contain, emails saying, "We know this is false, but it plays well," or "hide this from the DOJ," then the inference is unnecessary. The confession is in the text. This is why the swift timeline is fatal. Trump relies on attrition. He relies on the other side running out of money, energy, or time. But Judge Keller stripped him of time. She compressed the timeline of accountability. She forced a confrontation with the facts before the ballots are cast. So what do you do with this information? You share it. You don't just consume it, you distribute it. Because the only antidote to the gaslighting, the only cure for the fake news cries, is raw, verifiable documentation. When your uncle at Thanksgiving says it's a witch hunt, you show him the transcript where the president orders a crime. When your co-worker says it's political persecution, you show them the bank transfer. This is the turning point. The wall of silence has fallen. The king has no clothes, and thanks to Judge Mary Ann Keller, he has no place left to hide his naked ambition and his disregard for the law. Subscribe to The John Brown Show. We are going to be going through these files page by page. We are going to find the bodies buried in the footnotes. We are going to connect the dots that the mainstream media is too timid to touch. This is not over. In fact, the real trial of the century has just begun, and the first witness was the judge herself. Stay vigilant, stay informed, and remember, darkness cannot drive out darkness, only light can do that. Judge Keller just turned on the sun. Continued analysis, the specifics of the release and the legal precedent. We need to dive deeper into the specific mechanics of why this ruling is bulletproof against appeal, because that is the question everyone is asking. Why can't the Supreme Court stop this? The answer lies in the nature of the crime-fraud exception I mentioned earlier, combined with the specific procedural posture Judge Keller adopted. By making the ruling a matter of public docket management, rather than a substantive ruling on the guilt or innocence of the defendant, she insulated it from immediate interlocutory appeal. She framed this as an administrative necessity. The court cannot function if the docket is sealed. This is a brilliant legal manoeuvre. It forces the appellate courts to rule on whether a judge controls her own courtroom, rather than ruling on the specific privileges of the president. Furthermore, let's look at the banking logs again. We skimmed over this, but we need to drill down. The John Brown Show has obtained insights suggesting these logs track the flow of money from the Save America PAC directly into legal defense funds for witnesses who were testifying against Trump. This is classic witness tampering disguised as legal aid. If you are paying the lawyer of the guy who is supposed to testify against you, you are controlling his testimony. These files reportedly show the strings attached to that money. We cover your bills, you stick to the script. That is obstruction of justice, clear as day. And the January 6th communications regarding the National Guard. For years, the narrative from the Trump camp was that he ordered the Guard and Pelosi turned it down. These files reportedly contain the Pentagon logs and the White House switchboard records that definitively disprove that. They show the Pentagon waiting for an order that never came. They show the White House counsel begging the president to make the call, and the president watching television instead. This destroys the "I tried to help" defense. It proves the "I let it happen" reality. We also have to talk about the private exchanges regarding the fake electors. This wasn't just a wacky idea by some rogue lawyers. The files reportedly show Trump personally signing off on the strategy, knowing that the electors were fraudulent. When you sign a document you know is false and submit it to the government, that is a crime. It's forgery. It's fraud against the United States. The direct link, the ink on the page, is what these files provide. The impact on the Georgia case is particularly seismic. Fana Willis is prosecuting a RICO case, racketeer-influenced and corrupt organizations. To prove RICO, you need to prove a pattern of racketeering activity. These files, by showing similar behavior in Washington, in New York, and regarding the National Archives, establish that pattern. They show that the pressure on Brad Raffensperger in Georgia, find me 11,780 votes, wasn't an isolated emotional outburst. It was standard operating procedure. It was the Trump method applied to a specific state. The video mentioned legislative reviews. We have to think about Congress. Even though the current House might be friendly to Trump, the Senate is not. These documents give the Senate Judiciary Committee the ammunition to launch new inquiries, to subpoena new witnesses, and to refer new criminal charges to the DOJ. It restarts the legislative oversight engine that had stalled out. Finally, let's look at the human element of Judge Keller. Why did she do this? Why now? Perhaps she looked at the landscape of American justice, saw judges terrified of the MAGA mob, saw delays pushing trials past the election, and decided that someone had to be the adult in the room. Someone had to say that the law applies to everyone. Her ruling was an act of courage. In a time of cowardice, courage is revolutionary. She knew the threats would come. She knew she would be doxxed. She knew her family would need protection. And she did it anyway, because she understands what is at stake. It's not just about one man. It's about whether the Constitution is a suicide pact or a governing document. This release is the inoculation. It is the booster shot for a democracy that has been sick with disinformation. It hurts. It causes a fever. The patient is thrashing. But it is necessary to kill the virus of authoritarianism. So when you see the headlines tomorrow, when you see the spin, when you see the pundits trying to soften the blow, Come back to the source documents. Come back to the transcripts. Come back to the bank statements. The truth is there. It's ugly, it's messy, but it is undeniably, irrefutably there. Donald Trump is in a rage because he has lost his greatest weapon, the ability to create his own reality. Judge Keller just forced him to live in ours. This is the John Brown Show. We don't just report the news, we excavate the truth. And today, we hit the mother lode. Keep watching. The landslide has only just begun.